Welcome today to HR Recruit's virtual mock tribunal, which is being run by Vista Employer Services. My name's Jo Thompson and I'm a consultant for HR Recruit. I'm joined today by Vicky Roberts and Stephen Foster. They're going to provide a real insight into how a remote hearing is run, how decisions are made, and how actions taken can very easily become key features of a tribunal hearing. During the session, there will be the opportunity for you to ask questions using the chat box facility. I'm now going to ask Vicky and Stephen to introduce themselves and say a few words about the structure of the event.
Thank you, Jo, and it's an absolute pleasure to be joining you. My name's Vicky Roberts. I'm one of the lawyers in the team and I head up the learning side of the Vista business, and I'll hand to Stephen to let him introduce himself to you.
Thank you, Vicky. Yes, Stephen Foster. I head up the legal team at Vista Employer Services, and I've been to many tribunals. I won't give you how many years, but yes, I'd like to share some of that experience and hopefully pass some top tips across today. And feel free to ask any questions that you like.
Lovely. Thanks, Stephen. Super. So the plan for today then, we're going to have a look at the claim that's been raised by Agnes against her employer and her manager, and Stephen has the delightful job of playing the role of the manager today. So we're going to give you as realistic as we can experience of the on the day in a virtual tribunal hearing. They've been running now for a couple of years, started sort of very soon after the pandemic hit us all squarely between the eyes. And by all accounts, it's going to continue that way. It certainly seems that the tribunal service considers it to be an efficient way of running many of the hearings. So Stephen, as well as his many years of face-to-face hearings experience, has also got the CVP, the cloud virtual platform version under his belt now, and is going to share some insights in terms of what that process looks like. And we'll do it in the context of this fictional, but based on our experiences, case study. As you know, with all tribunal hearings, witness statements are taken as read. So when I started practicing, it was the case that the claimant and the witnesses read their witness statement to the tribunal. That doesn't happen anymore, hasn't done for a number of years, as I'm sure many of our audience know. But you've had the opportunity to read the witness statements through the virtual bundle that we shared, or Jo shared, as part of your attendance at this event. If you haven't had a chance to have a look at it, don't worry. We're going to summarize the case in a moment, give you the kind of basic facts of it. And what we will see is the cross-examinations in action. Because the case is quite involved, it's a case of direct race discrimination and of harassment. We're going to break this cross-examination down into its constituent parts and sort of explore some of the issues that are coming out. Why has the cross-examination gone in the direction it has? How do we feel that the cross-examination has gone from the parties' perspectives? And that's the opportunity. Please feel free to ask questions on the chat as we go. Stephen and I will both be keeping an eye on it. So we'll take your observations as we go along and any questions. Also, we're going to give you the opportunity to give us your views in the form of a Mentimeter poll about who do we think is going to win in terms of the various cases, and we'll run that 3 times to see whether views change as the case progresses, that roller coaster ride that I know some of you will be familiar with as the case progresses throughout the hearing. Now, we're together until 4:30. It's not going to be a straight run. We will take a short break in the middle of it just to give you a chance to stretch your legs and check phones and emails and what have you as we go through. Well, as I say, I'll take a break. And at the end of the session, it's decision time. And we will ask you to help us with the closing submissions, which will help me make my decision, because I've got the unenviable job of being the employment judge for this afternoon. And so we will see how the feedback comes through. I've just seen a note say the sound's poor. I'm so sorry. Oh, it's fine for some. Okay, well, we'll persevere. Thank you for those of you adding comments. Oh, lovely, super. Thank you for all the comments as we go. In terms of, I just also saw a question on the chat about having to take a break in the middle of the session. Yes, the recording is going to be shared of this as well. So if you miss a sections, you can go in and see the bit you missed, certainly as well. Okay, so let's take a little look at the case, Stephen, shall we, first of all? Talk me through the key issues, could you please?
Yeah, I think the key issue here is that this is an everyday management situation. The business manager, James Fletcher, believes that he's made an appropriate decision, which is fair, and it's a business decision which he thinks is in the best interest of the individual and the business. The claimant's position is quite different in that she has made the allegation that she's been put into a particular position, and she has linked this through not necessarily to her ethnicity herself, but her ancestry, which is quite an interesting approach. But what she's saying is that she has suffered less favorable treatment because of that treatment, and that's in a nutshell, really. This is often a situation that you find is that these decisions are made for the best interest of everybody, and it's often the communication of that and where we as managers and HR professionals can learn how we can improve those and avoid assumptions being made. I often describe it as individuals look at things through their own particular lens, and once they have something in their mind, they associate that happening to that lens that they're looking through, and this is one of those cases. And for that reason, the manager now has to explain the reasons behind the decision. So that sums up both sides of the case in a non-legalistic way, I hope.
Absolutely. And there is also a harassment complaint as well, isn't there?
Yes. So harassment, I always describe harassment as, it's often defined by everybody, but in non-legal terms, again, it's an act which affects somebody's dignity. And I think the key there, the bit that everybody misses, it's the intention is irrelevant. It's a case of how it's perceived by the individual, not how it was intended to be perceived. And that makes it a slightly different test for individuals. So harassment is one of those things which be alert to all the time. And often you see so many cases, well, that's not what I meant, this is how I put it across, or this is what I did. It doesn't matter, it's the perception, it's the point of view that you need to take into account on harassment allegations.
Absolutely, absolutely. So the nature of the management decision then, for those that haven't had a chance to have a read at the bundle, was an allocation to manage a particular aspect of the business. And the claimant is saying Agnes, as she's known, and she's accepted that people can refer to her as Agnes, was allocated the Polish market based on her heritage. So there's that direct link in that sense. And she's saying that that's detrimental to her because, of course, direct discrimination needs to be less favorable treatment, doesn't it? So why is she saying that allocation is detrimental to her then, Stephen?
Well, what it is that this is a sales force which is target driven. And what she's saying is that having been moved to that particular area, she has suffered in that she will have a more difficult time to achieve, ability to achieve those targets. So that's the detriment, that's the less favorable treatment that she's received. The manager's position is that he feels that she is best placed because it's a new market. So he's got his reasons, and you'll see as this case and you hear the evidence without wishing to spoil things, you'll hear the evidence as to that justification, and it'd be interesting to see as individuals how you feel this pans out, because remember, judges are humans, so put the law to one side, go with what you feel is appropriate and whether there's any lessons to be learned there, if any.
Absolutely right. Lovely. Okay, thank you, Stephen. So let me start with taking a quick poll for those who have had chance to have a read at the paperwork. What you will have seen in the pre hearing bundle, and remember, as normal, these things are exchanged in advance. So you'll have seen the witness statement of the claimant, Agnieszka, and of James, who is the manager. Stephen is playing James today, and he is also a respondent in his own right. So Agnieszka has brought her claim against her employer and against James Fletcher, her manager, personally. Why, Stephen? Why?
In simple terms, is that the business has the overriding obligation to the employees. So, but more importantly, from the claimant's perspective, they're more likely to have the deeper pockets for any compensation. In terms of tactics, individuals are often included because it applies pressure. Often that individual feels a lot more stressed and a lot more defensive, and that sometimes encourages settlement at an increased figure. So very often it's tactical, but ultimately there's 2 points to note. In most cases, the employer and the individual will work together. Another reason that you may separate out the individual and the company is that the company may have a defense that it took all reasonable steps, and it may effectively hang the employee out to dry. So if the individual is being trained, being warned, and is still being discriminatory, then the tribunal might find in favour of the company and say, well, fine, the employer did everything reasonable, and it may be that the individual is liable. But in most cases, you would sue the employer and the individual.
Yes. So for the purposes of this case, the respondent, the employer, Randolph and Tanner, has decided to run its defence alongside that of James Fletcher's. So it's the same respondent team. If it were to be separate, then you would see three parties effectively. So you would have three lots of representatives in that sense. And so it would feel slightly different. And as Stephen says, it's a decision that's made often by employers based on the extent to which they could run that reasonable steps defence. But for the purposes of today, work on the basis that the employer has decided to adopt Mr. Fletcher's defence alongside his own. Okay. So perfect. So that gives us a bit of an overview. Appreciate not the full detail for those of you who haven't had a chance to have a look at it yet, but for those of you that have, we'd be really interested in your views. So I'm going to share my screen in just a moment with a tool called Mentimeter. You may be very familiar with it. It's a polling tool. So if you have your mobiles at the ready, I'm going to share my screen and show you a QR code. And there's a couple of questions that we would like you to answer for us. First of all, will Agnes win her direct discrimination claim? And secondly, will she win her harassment claim based on what you've read so far? So obviously not having had the benefit of any sort of cross-examination as yet. So what will be appearing any moment now is the voting instructions. So you can either go in on your browser to menti.com and then enter that code, or you can use the QR code, entirely up to you. I'll give you a few minutes to just do that. And let me just share my screen in terms of the voting now. Then let's see. Oh, we've got a nice spread at the moment. Is it settling? Seems to be, doesn't it? Okay. Yes. So small majority in the favour of yes, that she will win her direct discrimination claim. So this was the point about the allocation of the project. Let's move us on then to the still coming in. Don't want to miss anybody. Let us move us on to the harassment complaint then next. stronger view on this one, Stephen, don't you think?
Yeah, that's interesting. That much clearer view.
Positive amount of jostling around the nose.
Well, that's much more definite, isn't it? Much clearer.
Definitely,
yeah,
definitely. Yeah. Okay. We'll ask you this a couple more times as the case progresses to see if there is a difference in view as the evidence comes out. Perfect. Okay, let me stop us there. Apologies if people are only just getting to vote. There's one or two still coming in, but I don't think it's going to change the overall mix. Super. Okay, so let's get to some thoughts about on the day then, Stephen, shall we? So this is a CVP hearing, as it's called, virtual hearing.
Yes.
Talk me through what's the same compared to sort of face-to-face face-to-face tribunal hearings, based on your experience.
I think that's a good starting point. I think anybody that's been to a tribunal, the good news is it's almost identical, and it's a good starting point. So the process, the procedures, those attending, you'll still have the tribunal sitting on it, a judge sitting on their own if it's an unfair dismissal. In discrimination cases, you'll have a panel, and the order of the witnesses is the same, and the evidence. So as you mentioned earlier, Vicky, the evidence in chief, which is your statement, is taken as read, and you go straight into cross-examination. So everything along those lines is exactly the same. I think what's worth pointing out is the biggest change is that tribunals themselves can be tiring. But what we've noticed, and the tribunal judges themselves have also expressed, is that tribunals by CVP are far more tiring. It's just the way that we operate, and I believe there's some psychology to this, is that we're trying to read body language that we can't see. We're not picking up the same signals, and therefore the brains are working harder. But whatever the reasoning behind it, it's definitely true that remote hearings can be more tiring. There will often be a few more breaks. But that's the biggest difference. It's the brain power that it takes. Procedure-wise, very, very similar. But there are some top tips that we can give in preparation for that, if that would be helpful.
Please do.
The first thing to do is, as you've seen today, there's always IT issues. The judges have become quite used to that. They're very calm, very placid about it. There's no rush. They will wait for people to turn up. But the most important thing is it's at least 2 days, and that does seem very tight. And some tribunals, or even the night before, will send a link to join the hearing. But at least a week before that, the actual hearing, they will have sent a guide and a test link. And it's extremely important that you do try that. The first thing to do is make sure you've got a laptop, iPads possibly, but do not try and do a tribunal on your mobile or just a mini iPad or whatever. You will be looking at documents, so make sure you've got a computer screen of some decent size. Privacy is another thing. Often judges are very, very tolerant, but they don't want people walking around in the background. You treat it as a courtroom, so make sure that you've got a room where the door is do not enter. It sounds very obvious, but you'll be surprised how many tribunals that people do have disturbances. Judges don't like that. They don't tolerate that. They don't want people sitting around. Some judges in the early days were actually asking you to pick up the remote and show the room to make sure that you didn't have anybody guiding you, and to make sure that you had a clean copy of the bundle. Make sure you've got a copy of your own documents. You want 2 copies of the bundle. You want the copy that you write on, you do all your post-its on, same as you would at tribunal, but make sure you have a clean copy. Even though you're not present in the tribunal room, make sure you're complying with the rules. Judges will go, well, they'll go in quite firm on individuals if they believe that that's not being followed. Half of them should check, but when they do, don't be the one that calls out. The other thing I think you need to do is taking the oath, or whether you're affirming. It's one of those things that's often overlooked. Now, if you're present at a tribunal, it's much easier. They'll run around in the tribunal to get the appropriate book if that's the chosen course. But if you're remote, make sure that you've got whatever the relevant holy text is. to hand. And make sure you do that in good time. Some tribunals, it sounds like a minor point, but some tribunals will not commence. If you say that you wish to swear on a particular holy book, they will not commence until the right book is there. So again, it's one of those things that's often overlooked. Dial in details, make sure you've got the contact details for your representative, your colleagues, and the tribunal clerk. They will wait, they will be patient, as long as you're making every effort to let them know that you are in the process of trying to resolve some IT issues. Don't panic, don't be trying to find those details on the morning. And then the final thing in relation to preparation is communication. Make sure you've got a separate means of communication with your representative in the group. And when you do that, make sure that you go offline. So you turn the camera and the microphone off, particularly in the early days, but even more recently, it's very easy for people to start communicating, think that the judge is gone, start chatting, and you've got the representative on the other side listening in. So in preparation, I would say that those are the top tips. Test, appropriate equipment, location, holy book, and communication channels, and test those before you attend the hearing.
We thought it was complicated in the old days when we were saying to people, make sure you had change for the car park that was nearest to the hearing, didn't we? Now,
absolutely.
Oh my goodness me.
Yeah, it's keys and everything
so much
else.
more to think about. Yeah, absolutely. And I think, I think we've done an awful lot of learning about working digitally, haven't we, over the last couple of years? That your point about, the judge sees everything, and of course your head and shoulders are that bit more magnified, aren't they, when there's only a few of you. And so if you start looking distracted, or like I've just done here, looked to a second screen, it looks as if you're looking into the middle distance. You're not, in fact, but actually just be very aware of that sort of thing, so that you look like you're paying attention and you're not distracting the judge when they're meant to be listening to the cross-examination, thinking, why is she looking over there? Because as you say, we are human, aren't we, in that respect? Absolutely.
Even looking down at the phone, it shows disengagement, and it means that you're not taking the proceedings seriously. And again, judges, for all their good qualities, they believe that are important, and therefore they will take that all into account. Shaking your head, tutting, you wouldn't do that in tribunal, so you shouldn't do it in the exaggerated format. The other thing that we often get asked is dress code. Just because you're feeling relaxed, that you're in your own environment, remember it is a formal hearing. It is a courtroom, so dress as you would if you were to turn up in person. But body language is one of those things. People forget to turn the cameras off and then start taking text and so forth. So yes, a very good point.
You can still have your tracksuit bottoms on the bottom half. It's just the top half you need to
focus
on.
You can do the BBC look, absolutely, yes.
Brilliant. Okay, thank you, Stephen. That's really helpful. Okay, so that hopefully gets us mentally in the zone, as in, we're just ready for this hearing. So as this is a discrimination claim, the claimant will go first. For those of you that are used to an unfair dismissal claim, you know that the respondent goes first in that situation. So what will happen is that the claimant will give her evidence first. And as I said, back in the day, it would be the case that she would have read out her witness statement, but it's what's called taken as read now. So the first thing that we will see is her being cross-examined by the respondent's representative, who is one of our colleagues called Chris, in the recording I'm just about to show you. What you won't see is Agnes being taken to give the oath or affirm, but that would be as you would perhaps be have experienced previously, where she'll be asked whether she'd like to give the oath or affirm, and she'll be asked to read out that she confirms that the evidence is true to the best of her knowledge and belief, and that she will tell the truth. That's the same as would normally happen. So imagine what's happened here, therefore, is that she has been invited to the stand. Of course, it isn't a witness stand. It's just she's been asked to give her evidence. She's confirmed that her witness statement that's in front of her is hers, that she's confirmed her address, she's given her oath, and then she's handed over, as it were, to the respondent's advocate in order to cross-examine her. And that's what we're going to see now. Now, we'll see the cross-examination in 3 different sections, and we're going to pause after each one to give you the opportunity either to ask questions or make observations. So we're going to see the cross-examination of the direct discrimination allegation in two parts. So the first thing that Chris will deal with as he cross-examines Agnes is the allegation that the selection is due to her Polish heritage, that causal connection that she has made, because that is disputed. It obviously has to be addressed in cross-examination. So we'll have a look at that first, and then we'll stop. And then we'll go on and look at the aspect of the direct discrimination claim, which is that selection was adverse to her. It was unfavourable treatment. So let's look at that causal connection first.
Can I just make a point there, Vicky? You've made the very important point there as to the causation and the link. Some of you who've been to tribunals might remember that in unfair dismissal cases, it's for the employer to prove the fair reason and that they followed a fair procedure. In discrimination, the burden of proof and the order is slightly different. And this is why Vicky's made it quite clear as to what the points are. The claimant has to prove that there is a reasonable case and reasonable belief for that in order for the burden to shift to the employer. If they don't do that, then they're unlikely to succeed on discrimination. Only when they've given that evidence is it then for the employer to say, actually, that's not the reason for the treatment. So that's why this is a reverse burden to the norm if you've been to an unfair dismissal hearing. So hopefully that just clarifies the order. Sorry.
Thank you, Stephen. Thank you.
Okay, good afternoon, Ms. Trzaskowska. Now, the tribunal's given me some limited time to cross-examine you, so let me get straight to the questions, if I may. It was part of your role to develop new work, and that would involve you working closely with new clients. Is that right?
Yes, but I wasn't ever given responsibility for developing new markets.
No.
That was something new that was put to me.
But as in your role as business development, it would be quite usual for a business developer to be involved in developing new markets and dealing with new clients, wouldn't it?
According to their experience, yes.
Not according to your own experience. You would never, as a business developer, deal with new clients?
Yes, you would.
And just dealing with the issue in isolation, just apart from your complaint, it would, let me check, it would therefore be quite normal for you, or let me say for a business developer, perhaps another member of your team or yourself, to be asked to deal with new clients as part of your role.
Yes, to deal with new clients as part of the role, but there is a difference when you're being asked to go into a completely untapped market.
But again, it would be normal for you or one of your team to be asked to go into a new market, because surely that's the goal of your business, to enter into as many new markets as possible. Is that right?
We do, but I would always take a view that if it was a completely untapped market and somebody hasn't, the business hasn't worked in that market before, and neither have I, that we would be doing that with some caution. There would either be somebody assisting or supporting with that, or that my targets would be adjusted to recognise that.
Well, let's break that down. To go into a new market then involves a business who wishes to succeed to play their best player into that new opportunity. Would you agree?
And that's what I would believe to be the case, but I don't believe that was necessarily the case in this instance.
We'll come to your belief and motivation in a moment, but do you agree with that premise that a business who wishes to succeed in a new market surely would play their best player in to try and succeed? Would you agree with that suggestion?
They should.
Yeah, that's good enough. You take issue, though, in relation to the motivation for your selection, though, don't you?
Mm-hmm. Because when you've just said there about the best player, I don't perceive that I would be the best player for an untapped market in that sense. But what I have a sense of is that the reason why I was being put forward as the player for that market was a perception about my nationality.
Yeah, but let me break that down then further. You may agree or disagree as to whether you felt you were the best player, but leaving aside the point that we'll come to on nationality, do you feel that your manager, wanting to succeed, believed you were the best player for the reasons that we'll come to, but do you believe that he was placing you in that opportunity because he thought you were the best player?
He thought I was the best player because he thought I would go in there and speak the language. That's what he thought.
And we'll come to that, but isn't being told that you're the best person to carry out a job, isn't that an endorsement of you? Isn't that a compliment of you?
It is, if the endorsement is about your actual skills, and this wasn't. This was about whether I was going to speak Polish or not.
Well, how do you know that? How do you know that it wasn't a combination of factors?
Because he doesn't realise that, you know, I don't speak fluent Polish, but he just made an assumption on that basis. I haven't dealt with Polish markets previously. It's an untapped market. We don't really know that much about it. It's not the kind of thing that I have done from scratch before. So I would have expected that if he wanted to give me that opportunity to try and develop me and try and aid my career progression, then I would have thought that perhaps he would have given me some support in doing that, which I didn't get. And, you know, I just would have thought that some difference would have been made to my targets as well, because how can you expect someone to meet the normal targets when it's a challenge that they haven't faced before?
Well, you raised several issues there. Let me take them one at a time. Were you told by your manager that the new business would require you to speak in Polish only?
No, he didn't say that.
So we were talking about assumptions being made along the line here. You assumed, therefore, that you'd have to speak in fluent Polish.
I could not see any other reason why he wanted to put me into that position.
Yeah, but the question I asked was, and tell me if I'm right or wrong, without being told that you have to speak in fluent Polish, you assumed that you would have to.
That's the only reason I can think of for him giving me that work to do.
I think we're agreeing on that, but feel free to tell me if I'm incorrect. We also, can we agree that you assumed that there would be a negative impact on you being able to reach your target without actually trying to reach the target? Again, that's correct, isn't it?
It's pretty common knowledge that if you give somebody a difficult, untapped market to go and deal with, it's pretty obvious that you are not going to fly with that from the off. You know, it's going to be challenging. It's going to take time, and you know, having the same targets to meet to do that, that's just not fair.
Well, it's not fair if you are not able to meet the target, perhaps, and you don't have them adjusted. But looking at the assumptions here, you assume that you won't be able to reach target, and you assume that that will be a difficult market. And you must assume that because you have told the tribunal that you didn't know a lot about this market. So those were your assumptions, weren't they?
And that's exactly what I found. I found it to be a challenging market when I was doing the work.
But we're looking here at the motivation and the way you take issue with you being selected. We're agreeing that there is an attempt by the business, at least in principle, to identify and play in the best player. But then looking at the motivation, you say it was less favourable treatment for you to be played into that new opportunity because of your Polish heritage. Is that right?
Because the assumption was made that I would just go into that and be able to deal with it all because of my background.
Okay, so that's our first section, picking up with on the points that Stephen was making just before we saw it, which is to say that it's the claimant's job to put forward facts from which the tribunal could reach the conclusion that there was a link to the decision to allocate her the Polish market based on her heritage or ethnicity, nationality. You know, the definition of race in the Equality Act is broad enough to cover all of those requirements. Thoughts or questions on that point? First of all, please feel free to put them forward in the chat. An interesting point here. Is there any info on her previous performance? Stephen, why would that be relevant?
The reason for that relevance is that I think the claimant's own language was there. She couldn't see any other reason. So that went to that goggles or the lens that the individual looks through from their perspective. If there were performance issues, this is where cases often arise. Somebody's being managed and they often allege that they're being discriminated, treated less favourably, bullied even, or even harassed just through pure management. Now, the management can be good, it can be bad, but it doesn't necessarily mean that that was the discrimination or harassment. So that's an important distinction. If the individual here has identified that there may have been performance issues that could explain why we were managing and moving that individual, that may explain the decision taken by the business and may mean that it was nothing to do with ethnicity. So it's a very good question, that, and I won't spoil the answer.
No, quite so. We'll come to that in just a minute. Lovely. A really interesting point here. Agnes kept making the point that it was an untapped market, but isn't that an assumption?
Yeah, and you will see that Chris, the advocate there, was very, very clear on that, is that that's the strongest point. It was assumptions, and we're trying to prove that actually there may have been good business reasons. You've linked these things. That's not the business's decision. That was your decision or your explanation for it. So it's a subtle way of proving that actually you may believe that, but it doesn't mean it's right.
That's it, trying to break.
Yeah, and the only other point I was going to make, you often hear this in discrimination cases where is the person doesn't feel it was fair. But fairness, again, lack of fairness does not mean it was discriminatory.
No.
Even bad decisions can mean they're bad decisions, but it doesn't mean that they were discrimination. It's got to be linked to the protected characteristic. It
doesn't make for a great defence, that said, does it? Yeah, but it's
we've escaped
technically
on
right.
That. Yes, we have escaped on that. So it's not the best of defences, but if that's all you've got, it's better to be open about it and say, look, bad decision, but not related to the protected characteristic.
That's it, exactly. And it's all about a manager showing their workings, isn't it? What is the reasoning behind the decision in order to be able to defend the claim if what Agnes has done is enough to shift the burden to say, right, now it's your job, employer, to prove the absence of discrimination. And the test is high here, isn't it? And once that burden is shifted, it's a high burden, isn't it, for the employer to respond?
It is. And I think that burden just become higher in relation to certain elements of discrimination claims where it's not too hard for them to clear the first burden. But again, the harder element for them is to actually prove that it was linked to the protected characteristics. So focus on that. Was there a decision? What was the reason for that? Can we prove it? And if you can do that, then you're halfway home.
Yeah.
Important point I've just seen on the chat there was what was the discussion? What was the discussion? And that is, again, another fundamental point. In most cases, whether the unfair dismissals, protected disclosures, it's the lack of communication that allows the individual to come to the assumptions that they do. But sometimes those assumptions can carry weight. And now, as you see in this case, it may have been an assumption, but now it's on the burden shifted to the employer to prove otherwise.
Yes, absolutely right. And so often we see tribunal hearings with, lever arch files full of paperwork.
Yes.
But as we've got here, a case without any bundle at all, really, other than the witness statements, no documents at all, which doesn't help us in terms of the quality of the discussion that was had. And there's some really good questions here that would be absolutely key to the preparation of this. Did she ask for support? Did she have the opportunity to turn this down? What did she say? All of those things that are relevant to that conversation. But it all does go back to the link between the reasoning, the decision making of Mr. Fletcher, the manager, as to why he had selected her. And if this is in fact less favourable treatment, which is the bit that we want to go on and have a look at next. Why is it, in Agnes's view, less favourable treatment? Yeah. So let's go on and have a look at that in a moment.
If we move on then to the second allegation that you raise, you state that you were offended.
Apologies, just jumped on one too many. Bear with me just a moment.
So is the assumption that your Polish heritage might give you an advantage in a sales environment?
Yeah,
Yeah.
That's the assumption that was made, and that's why that's why they didn't adjust my targets, because they thought it would keep up there with it.
Leaving the target issue aside, in relation to the motivation to place you in the role, I think we've agreed that the motivation is to play in your best player, which I say is an endorsement. And then the motivation is also to identify something in a sales environment that will give you an advantage to allow you to further succeed. So again, isn't it positive and favorable to allow you potentially to take advantage of commonality with a new client?
But doesn't that conflict with what James actually said to me? Because he suddenly mentioned to me about some issues with my communication. So if he thought there was issues with my communication, how does that make me a best player to build rapport with a new client?
Well, do answer my question though, because I'm putting a principle to you and you're giving evidence about something else here. So my question to you is, isn't it advantageous? It occurs to me that it would be, to allow you to play into an advantage in a sales environment, that being the commonality of heritage with a otherwise cold or new relationship. That's the principle I'm putting to you. Do you agree with that principle in sales or
No,
not?
I don't. No, I don't, because my background, I don't know anything about that market.
Do you know anything about sales?
I do know about sales, but there's no advantage from my
sales.
background to that. There was no advantage from my background to that.
Well, let me put that to you then. In a sales environment, I'm a lawyer. I'm not a salesman. So I look to those who are better salesmen than me. And I look to the Harvard Business School, the Harvard Business Review, that examines the key recipes for success of salesmen. And I can glean just from looking at the basic sales concepts and environments that having synergy, having empathy, having commonality, having shared interests are very clear advantages in a sales environment. So again, going back to the premise that
I didn't have any of those shared interests or commonalities at all.
Well, if you're speaking to somebody in Poland and you have a Polish heritage, would that give you, and correct me if I'm wrong, would that give you any commonality or ability to discuss any shared interests? It wouldn't.
No, I haven't lived in Poland. I don't believe it would give any commonality there at all. I haven't lived in Poland, and James made an assumption that I would have all of these things about the culture baked into me just because of my name.
And what, just explain to the tribunal then your heritage. What's the heritage of your parents?
My parents are both Polish.
So how much do you know about Polish culture, would you say?
Not a huge amount.
Your
I was
parents didn't
was
teach you
born.
about Polish culture?
I was born in England. I was raised in England. My parents did their best to fit in to England, and so we didn't speak Polish at home. There was just little bits of it that I picked up here and there. But my father was adamant that, you know, when in Rome, you do as the Romans do. And so I was brought up in England, and I consider myself to be a British citizen, and I do not know much more about Polish culture than many other people.
No, nobody's questioning your citizenship here. We're just looking to establish whether you had an advantage due to heritage, whether that advantage was slight, whether that advantage was great. We wouldn't be able to establish that over somebody who didn't have your heritage. So looking at that, are you saying that your parents didn't teach you anything about Polish culture that might give you an advantage in speaking to people who are Polish?
No more than what some other people may pick up around Poland. There may be other people who have had holidays in Poland, who have absorbed themselves in other types of Polish culture that would know more than I do.
Well, what I would suggest to you is that your manager is playing in his best player. It's an endorsement of you. It's a compliment of you. And you're distancing yourself, I would suggest, from the fact that you would have an advantage due to your Polish culture in a Polish sales environment. It would have offered you better synergy, empathy, commonality, and you're distancing yourself from that for the purposes of saying to this tribunal that you were treated less favorably and are so offended by that. What do you say to that?
I am offended by that. He's made an assumption about me just based on my name. He knows nothing about my background. He doesn't know how much I know about Polish culture. He never asked me. He never took the time to find out. And the very fact that he said to me, there have been issues with my communication, which had never been raised before, just makes me then believe that that is exactly the assumption that he'd made.
But he actually tells you, so looking at motivation, he actually tells you that he thought that you would be the best person to undertake and succeed in the role, doesn't he?
Because of my communication.
Well, he actually tells you also in his evidence, the combination of your statement is that he thought that you would be the best person to do it. And his evidence actually accepts that it was the cultural advantage that you might have. So he's trying to give you and let you play into an advantage over others. Isn't that more favorable treatment on the face of it?
No, he made an assumption on something that he didn't actually know about. He never asked me. He never checked that.
So there we have it.
Lots of debate going on in the chat there, wasn't it?
Isn't there just? Yeah. Let's pick up this really interesting point about the might her name come from the fact that she's married? May it be that she isn't actually Polish? From a technical perspective, of course, you can still be discriminated against on the basis of a perception. Yes. So if somebody's treated unfavorably based on the perception of, in this case, their ethnic background or their nationality or their race, then that would still fall within that technical definition, of course, of race discrimination.
Yeah.
Which hopefully picks up one or two of the points about how did he even know. So even if he was wrong in his perception, if he was linking his decision to selecting her to a perception of her Polish background, then if that decision is unfavorable, then that definition of direct discrimination can be made out.
It's an important point. This is a good argument where I said somebody said that the advocate's flogging a dead horse here, but the argument you've just said is that the manager could easily turn around and say, look, I made no assumptions about ethnicity. She may have married into that name and therefore she wouldn't have had any advantage. That wasn't the reason for my decision. It was purely to do with best person, best placed, and there was a business reason to move it. So you can always take one argument one way or the other. To deal with the point about flogging a dead horse, it's important that the advocate puts the employer's position to the advocate. If they don't, the judge will treat the evidence from the claimant as accepted. So it has to be challenged, even if it's not a good challenge. Sometimes you need to think about, okay, well, he's got the point across, is that this is yet another assumption. So it's a dangerous corridor to go down, and you may end up in a corner, but he has to do that. So be aware that the advocate has to challenge certain things.
Yes, quite so, quite so. And what are thoughts on the chat in terms of how successful has the advocate been in being able to establish that this actually wasn't less favourable treatment at all? It was him playing the manager playing his best player, and it was an opportunity, don't you know? What's your thoughts?
My thoughts.
Let's see what the chat says first.
Yeah, okay.
Because you're biased, Stephen, you're the manager.
Yes, I was going to say, thanks for the invitation.
We'll hear from you in a minute.
Yes.
Think he's doing well is a thought that actually is this was as bad as she thought it was, interestingly. Wonderful. Thank you.
Can I just ask you, if you're thinking he's done well, think about what we're aiming for at the end here is the judgment and the submissions that Vicky has mentioned at the beginning. Just up down 2 or 3 points that make you feel that way. And conversely, if you're not convinced, jot the 2 or 3 points down as to why not, because that will become useful when we move through the session today. Absolutely.
Brilliant. So let's finish off then with the third section of the cross-examination, which is around the allegation of harassment. So the incident here, for those of you that have had a chance to look at this, is an allegation that Mr. Fletcher referred to Agnes wearing her Polish power outfit in the context of a meeting. Now, the point here on this one is that Mr. Fletcher's evidence is that he can't recall saying it. So in terms of dealing with this in cross-examination, going back to Stephen's point earlier, it has to be put to her that she may well be mistaken. But of course, that's quite difficult to say to a claimant who may be upset, clearly feels things quite personally, that she may be mistaken. So let's have a look at how you deal with that practically, and we'll see Chris in action for his third and final time.
If we move on then to the second allegation that you raise, you state that you were offended by his comment that you were wearing a Polish power outfit. Is that correct?
Yeah.
Now, I must say that I've never heard of a phrase like that. Have you heard of a phrase like that at all in the past?
Never before have I ever heard anything like that. And that's why I was so taken aback when he said it.
And despite having never heard of it, are you aware that it's a saying or a phrase that's used with any commonality?
Never heard that before.
Would you agree? And it's certainly my perception, that's a very unusual observation to make.
Yeah, it is an unusual observation to make. It's not something that I've ever heard anyone say to anyone before.
And before this, these issues arose, did you otherwise have a good relationship with Mr. Fletcher?
When I saw him, yes, it was fine. I didn't see an awful lot of him. He never really did, proper one-to-ones with me to see how I was or anything like that. It was very factual. It was just very information flow.
And you'll see from Mr. Fletcher's statement that in relation to the, let's call it the first part of your case, there seems to be a degree of agreement that, look, you were asked to carry out the task. He agrees that there are some reasons in relation to heritage that might have best placed you in relation to the task. But in relation to the second part, this allegation of the Polish power suit, he says, look, I deny that. Are you saying that Mr. Fletcher is lying by saying that he denied that?
He must be. He said it. I
Well, you
couldn't have
say
made
he
that
must
up.
be lying. He says that he didn't say it, and it's a very unusual phrase to say. Isn't there room here that you misheard it?
I don't believe so.
But is there a chance that you may have misheard things?
No. How do you misheard here? You've got your Polish power suit on.
And you don't invite any of your colleagues along to the tribunal to endorse having heard that either. You're not bringing anybody else with any evidence to corroborate that, are you?
No, because nobody wants to get involved. No one wants their career to be, to have any problems with James in the future. And I don't want to put them in that position.
Well, did you ask them, or is that another assumption on your behalf?
I haven't asked anybody because I didn't want to put them into that position.
So it is another assumption on your behalf. Thank you very much. I have no further questions for you.
Okay. So Stephen, talk us through why Chris has taken that particular approach with this cross-examination.
Yeah, so what we've got is a very clear witness who's adamant that something's been said. And what he's now done is he's linked that to yet another assumption. I think we saw on the chat, everybody saying, well, where's the evidence of this? And that's the crucial thing. So if you haven't got the documentary evidence, the next best thing is the witness statement, somebody coming along to back up what you're saying. And you'll see in the bundle, there's very limited evidence for either party here. But we talked about possession of a witness. There's nothing to stop claimants calling witnesses. Although they're your employees as employers, there's nothing to stop tactically the claimant getting the statement that they want and phrasing it in a way that they wish it to come across. So make sure that you speak to witnesses. If the employer wants to defend this, really the onus is upon them. They should bring witnesses that were present to say, I was there, I was 6 foot away, and I don't recall either hearing that statement or her raising the matter with me. So think about your witnesses. If you've not got the documents, goes to the witness statements and bring something to say, I didn't hear it.
Absolutely. So some really interesting points on the chat here as well. Confidential witness statements is a good question here, but of course the evidence is this is a public forum. A real one is a public forum, so in that sense the evidence would have to be given in public forum. And so the claimant's concern, if you like, about other people feeling uncomfortable about giving their evidence is a real point, isn't it? You can see why these concerns get raised.
I had a tribunal, it's a discrimination one, but that was exactly the claimant's evidence, in that she didn't want people to feel as if they were compromising their position of work. It's important to note 2 things from that. Confidentiality, even if it was given, if we dealt with this as a grievance, we can't guarantee confidentiality because these hearings are public. So that's the first thing to be clear on. The second thing is the law protects people from a detriment. And one of the protections they get is from what they call a protected act. But if you raise a claim of discrimination, or you are a witness to those proceedings, you are protected. So the excuse of not wishing to call somebody falls away straight away, because the judge will know that if there are any repercussions for any individuals, the law protects them. So it falls away and weakens the individual's position if you don't call that evidence.
Yeah, quite so. And as it appears, of course, Agnes did not give the employer the opportunity to investigate all of this internally. She just went to the hearing, went straight to the tribunal, obviously early conciliation first, but went straight to the tribunal process, which will be relevant if her claim is successful in terms of the compensation. So we'll have a look at that in a short while. Really interesting point, and so eagle-eyed on the part of one of our attendees here in terms of the evidence that she's given. It's changed from Polish power outfit to Polish power suit, and that may be relevant to the quality of her evidence. The judge needs to make this decision based on balance of probabilities. Is it more likely than not that these words were said, in order to be able to determine this question of fact at this point? Super. Let's, I think, take a well-earned break. And in that break, I'd really like you to have a further think about likelihood of success. So immediately after the break, I'll take another poll as to whether we think that the claimant is likely to win first the discrimination claim and then the harassment claim. Then we will go on and have a look at the respondents' evidence, and poor Stephen will have to have the joy of watching himself on telly, which is never great, I know. But you're taking it for the team today, aren't you?
Yeah,
Steve?
I'm afraid so, yes. Yeah.
Lovely. So shall we take, is it 9 minutes okay for everyone? So we'll take until 10 past. Let's stay in the call, I would suggest. We'll just pop ourselves on mute and turn our cameras off, but we'll stay in the call as well. We'll keep monitoring the chat. Stephen.
Can I just use that as an opportunity? At the beginning of CP and remote hearings, tribunals were disengaging and asking people to dial in. I would say 99% now, you'll be asked to switch your cameras and your mics off, but leave the connection on, which goes back to the point I made about the preparation. Make sure that you leave the room. Don't start ringing or texting people whilst you're in the same room. Leave the room. But do turn your mics off, do turn your cameras off, and it's good practice for the real thing.
Lovely. All right, so we will see you at 10 past.
Cheers.
Okay, welcome back, everybody. So just a quick reminder as to where we are. I've just made a note of this while we were on our quick break. The vote was 54 in favour of discrimination claim being successful, 54 plays 35. And for the harassment, the vote was 20 that yes, she would, versus 65 that no, she wouldn't. So obviously there's that. At the moment, that first perception was more likely to win the discrimination claim, less likely to win the harassment complaint. Let's see what changes, if anything, as a result of Agnes being cross-examined. So for those of you who clicked away from the Mentimeter after the last one, let me just reshare my screen as far as the voting code is concerned. For those of you who still have it up, you can go to the second round of voting, and I'll click onto that in just a minute. A change, Stephen.
That's a big swing, isn't it?
Isn't it?
Good.
I feel like John's now.
Not biased at all. I think this is an important point, though, Vicky. Is I say this to witnesses when I'm in tribunal, and it's I don't like referring to football analogies, but it really is a game of two halves. You'll see the mood of the tribunal swing. You think you've done really well, and then by the time the claimant comes on, you think, oh dear, or vice versa. You think you've not done so well, and then suddenly you put your witnesses on, and you feel that it's balanced out, and you've done very well. So
yeah, quite so.
It's good to see this actually, because it reflects reality,
doesn't it? Just yeah, absolutely. So we've got so let's capture this at 2161. I appreciate there might be one or two people voting, but I don't think it's going to change the broad balance. Let's go on and have a look at harassment then. See whether this changes like the discrimination one has done. So will Agnes win her claim of harassment? They're coming in thick and fast for the nose.
Yes.
And actually, it's very consolidated clear. The previous view, isn't it? This one, yes. Interestingly.
Yeah, absolutely.
Okay. So let's crystallize that one at 6 and 76. and I'll put this up on the board in just a minute so that we've got it when we look at it and ask you to vote for the third and final time. Thank you, everyone. That's great. I will stop there. And let's go on and have a look at then the evidence on behalf of the respondents. So the process is effectively the same. We have one witness on behalf of the respondent, and of course he's giving evidence on his own behalf as well. Remember, we've got two respondents here. So exactly the same would apply. His witness statement would be taken as read by the tribunal. He will be asked to take the stand, take the oath or affirm to say that his evidence will be the truth. He will be taken to his witness statement, asked to confirm that it's his signature, and then he will be handed over at this point to the claimant's representative, who is played by another of our colleagues, Tim Cross, to cross-examine Mr. Fletcher, aka Stephen, in his capacity as the line manager. So we're going to see this evidence broken down in a few parts as well, just as we've seen the claimants. So we'll have a look at the couple of sections. But Stephen, just talk us through this, because from a practical perspective, of course, you don't know at this point whether the claimant has discharged the burden to shift the responsibility onto the respondent, because the judge doesn't make any findings at that point.
No.
So how is this dealt with practically in that light?
In reality, the tribunals at the moment have become slightly more cautious in that what they'll do is that they will hear all the evidence. Once they've decided that there is a case or potential case to answer, they're very unlikely nowadays to strike a discrimination case out, which is disheartening, because some of them you do feel don't have legs to stand on. But only in the most obvious of cases will they strike out nowadays. Generally, they want to hear all the evidence before making a decision. And that's where we find ourselves. You may or may not feel that the burden's being discharged, but in this case, there's enough there that they will want to hear the respondent's evidence now.
So the respondent's case is going to work on the assumption that the claimant has. So the preparation works on the assumption that the claimant has discharged their burden, so that they have to prove the negative. Yeah.
Yes. And that's sorry, I was just going to say that's the best way to be, because if a decision has been made, you should be able to explain that decision, and you should be able to back it up in evidence. And I think a number of delegates today have already realised that we're light on the documents.
Quite
so. Word against word.
Yeah, quite so. And there is plenty of case law as to actually how high this burden is, Stephen, isn't it? In terms of evidentially, what does the employer, the respondent, have to establish here?
Yeah, in simple terms, it's a clear reason. What's the reason? If it wasn't to do with the protected characteristic, in this case ethnicity, what was the reason? Now, it does sound like a high burden, but actually, remember what I said before, even if it was a bad decision, provided it's nothing to do with that protected characteristic, that can be your defence. So it feels like a high burden. It's often you feel like you're trying to prove a negative. But actually, you just need to be clear on what your reason was, and ideally have a contemporaneous note.
But it has to be for no reason whatsoever related to her ethnicity, does it? Yes. So it doesn't matter that it was unintentional or unconscious. So, you know, all of the good discussions we have about unconscious bias, for example, have good reason, because actually we want to make sure that there is a conscious decision making that is evidence that's got nothing to do with that person's, in this case, ethnicity.
Sorry, that's an extremely important point, not just for discrimination cases, but there's just been a very recent case. If you read our In View monthly article, there's just been a one in relation to protected disclosures, and that's exactly the point. It doesn't have to be the reason or even the sole reason. It has to be not tainted at all, effectively, in the decision making.
Yeah, absolutely. Now, let me just pick on a really interesting question here on the chat, Stephen, before we go there then. Can strikeout happen prior to the respondent giving evidence? So on the day of the hearing, as opposed to, say, in preparation or as part of preliminary hearings?
I would say technically, yes, it can. Normally, if you felt the case was that weak, you would be asking for a preliminary hearing. So before we get to the hearing where there's full evidence being exchanged, you would normally ask for a preliminary hearing. for the judge to decide whether or not the case has reasonable prospects. And you can ask for two things there. One, you can ask for a strikeout, which is extremely draconian, or you can, if there's doubt, you can ask for the claimant to be ordered to pay a deposit, which is a good tactic. And a deposit is a sum of money based on their means. But what it means is that two things. One, they lose their deposit if they lose the claim, or an element of the claim that the deposit is placed against. And more importantly, at that point, they're on notice that they could be responsible for your costs, your legal costs and otherwise from that point on. So it has an extremely persuasive factor. So often apply for a strikeout, definitely apply for a deposit order. You're more likely to get the second nowadays than the first, but that would normally be dealt with before you could turn up for the full hearing.
Yeah.
Don't be afraid to push for that. Lots of judges are, particularly the newer judges, and I apologise to any that might be on here, or part-time judges, but you find that the confidence comes in the more experienced judges, in that they are familiar with what the test is and be prepared to be challenged. A lot of less experienced judges will prefer for the judge at the final hearing, and they just say, well, we can hear the evidence, we're here at the final hearing. Don't be afraid to push your advocate to push for a preliminary hearing.
Absolutely. And there's an interesting question here. Is it not a barrier to justice? It's a really interesting point. And in theory, you could say, yes, it is. But what it's trying to do is strike the balance with the fact that obviously tribunal hearings are free to access. And therefore, it sort of creates an expectation, if you like, that people go to and use the court resources and put employers through the burden of a hearing when they feel strongly and are able to demonstrate with evidence that the case that they have in front of them. So it's trying to address in any way it can without requiring fees, if you like, for people to take the process seriously.
It's used in the most extreme cases. So in order to put people's minds at rest, yes, justice comes absolutely first. Deposits are rare. Strikeouts, particularly in discrimination cases, are extraordinary. Yeah. So it's protection of the public purse only in the most obvious of cases.
Yes. Yes.
The other point there is if they're supported by a union. Funding is a common thing that claimant lawyers will discuss with their clients, but that is often subject to a 51% success test. So if they bring the claim, that may proceed to a certain point, but the unions will often cease to support and other funding sources if there's not a 51% or more chance of succeeding.
Great stuff. Thank you. Okay, so let's see the respondents' evidence in action then. So what we're going to see is cross-examination of Mr. Fletcher, aka Stephen, as I've mentioned, by my colleague Tim Cross, looking at, first of all, at the discrimination complaint. So we'll see it in three sections, as we have done, four sections in this instance. We're going to three different sections around the discrimination complaint, and then we'll see one section relating to the harassment complaint. So just to kind of break it down into bite-sized chunks. This first one is looking at the defence that the claimant's selection was not unfavourable to her. So what Tim Cross is doing here as the claimant's advocate is challenging that point, that it wasn't something that it was unfavourable to the claimant by selecting her to look after this emerging market. So let's have a look at what we've got here.
Good morning, Mr. Fletcher.
Good morning.
You have in front of you a copy of your witness statement. At the bottom of that statement, it confirms that the content of this statement is true to the best of your knowledge and belief, correct?
Yes, correct.
Yeah. And you're an experienced manager, having started with the company in 2016, correct?
That's correct, yes. Business development manager I was then.
Yeah, so that was the same job as the job that my client's doing, correct?
Yes.
Yeah. Would you regard yourself as a straightforward and transparent individual when dealing with work-related matters?
Yes.
Yeah. Is it fair and would you also regard yourself as a fair and reasonable manager?
Try to be, yes.
And you would accept that it would be wrong to disadvantage or harass people because of their race or nationality?
Of course, yes.
And you'd also accept that as a manager, it would be incumbent upon you to set targets that are realistic, reasonable and achievable.
Our sales team are driven by targets, yes.
Mhm.
I wouldn't say that they're unreasonable.
It would be correct, wouldn't it, that if targets were not adjusted to account for a particular difficulty, then it's possible that those targets wouldn't be achievable, and that if so, targets aren't met, that would result in a financial detriment in terms of lack of commission and so on and so forth.
There is a detriment if people don't hit their targets, but they can be adjusted if circumstances change or the economy changes.
Sure. And when appointing my client to the business development for the new untapped Polish market, it's correct that you didn't make any adjustments to targets at that time.
We didn't. She seemed happy to accept the new role. She didn't raise the issue. We didn't cover that, but it's something we could have looked at had that become an issue as she developed the market.
Would you accept that it's particularly difficult to break into an untapped market in a foreign country if you're not fluent in the language, you can't read or write in that language, or if you've got less or limited experience of developing an untapped market?
Only if they were requisite for the role. You've got to remember that hotels have staff that are fluent in English, and therefore their English was adequately fine to converse with those in Poland.
And in terms of my client's background, it's correct that she's not Polish, isn't it?
I would say that my understanding is that her parents are Polish rather than
parents are Polish rather than her. She's British.
Yeah,
it's correct that she's not fluent in Polish.
I wouldn't know that. As I said, that wasn't part of it, but I wouldn't know.
Okay, I'll put it to you that's the case. And it's correct also that my client doesn't read or write in Polish.
Again, I wouldn't know, but that wasn't a factor in my mind at the time.
Okay, but you wouldn't disagree with that if, as per what the claimant said in her evidence?
I can't agree or disagree. I've never asked or seen her required to speak or write in those languages.
Okay, I'll put that to you. That's the case. In paragraph 8 of your witness statement, you say, I remember saying to Agnes that she would be the ideal person to take on the task given her experience before joining us. What experience are you referring to there?
Sales experience, just general sales experience, yes. Okay. Very experienced, very driven. That's what led me to appoint her, really.
But you've heard my client's evidence where she herself suggests that there is other people within the team who'd be better placed to develop sales in an untapped market. Some of them have had developed new markets in the past, which suggests very much that she hadn't, and there were other people that had. That's correct, isn't it?
That's your suggestion, but that's not correct. No, the simple position is that people within the team have developed markets, as she could have done had she stayed with us.
She could have done. So can you give me an example of where she said she has done?
No, as I said to you, it was the experience that she had, and if you look at her statement, she does actually accept that part of her role is to develop growth of existing clients and to develop networks and new clients, and this would fall into those latter two categories.
Slight difference developing an untapped market, is there not, Mr. Fletcher?
So sales is sales, and sometimes you need, even with existing clients, you need to make cold calls to develop that. It's the market changes nothing. The language is the same.
Just so I'm clear, you accept that it's correct that other members of the BD team did have experience of developing the new untapped markets?
They were given the opportunity and were able to develop, and I'm sure Agnes would have been equally able to do so on her sales experience.
Okay. Now, you say in your statement...
I'd just like to add, the reason why I didn't move those people was that because they developed those markets and gained relationships, it didn't seem appropriate to move them from that new market to another new market. It was to give Agnes the opportunity to do the same.
So this is our first point then. How successful has Mr. Fletcher been in establishing, oh, this wasn't detrimental to her? Thoughts, anyone?
whilst you're thinking about that, I'll just make type in some comments first, possibly. A good point to note at the beginning, and it's slightly deliberate on my part, maybe over-exaggerated, but you'll see that it took time for this witness to warm up. You'll see barristers and advocates asking very close questions, and if you ever attend Vicky's training, you'll know the benefit of what she talks about as a sandwich, where you start with an open, you've got your closed, open, closed questions. These were very close questions, and basically were pushing me to say yes or no. And we do witness training that helps you wiggle off those points, but it's a very important observation. So if you saw nothing else in that section, you don't want to be the person that's being pushed to say a yes or a no when that's not what you want to say. And go in warmed up, have your explanations. It took at least 2 minutes before this witness warmed up.
Absolutely, absolutely. And you may feel you've lived and breathed this case before you arise, but it's always worth having another read over your witness statement, isn't it? All of the documents, remembering where everything is, so you don't have that brain freeze moment that we've all done, haven't we? You know, outside a tribunal or in it, and that's thinking, oh, I can't remember what date that was, or I can't remember when that, you know, because our brains, when we're under stress, have you know, ways of causing a strain in that sense. So yeah. So some interesting points here about it could have been detrimental, not that it was detrimental. So what you're looking for here is unfavorable treatment. So you're not necessarily looking for a tangible evidence, but something where somebody felt that, and a reasonable person might feel that this person has been subjected to some form of detriment.
There's an important case on that. I think it was about 2 years or just before the lockdown, in fact, where the police had moved a pregnant lady to effectively an office-bound role following a risk assessment, health and safety risk assessment. So it was done for all the right reasons, but actually she perceived that to be limiting her career prospects, and therefore, again, they were facing a discrimination claim. So it shows you even the right reasons can still be discriminatory.
Quite so. Good. Okay, so let's go on and see where the cross-examination goes from here. So what we'll see next is Tim taking the next element of the evidence that he needs to put to Mr. Fletcher. You'll have heard him actually in a couple of areas saying, I put it to you, I'll put that evidence to you, so you don't disagree. And that's the technical point that Stephen was talking about earlier in terms of putting some of this evidence in front of the witness, because otherwise the judge will take it as being accepted if it's not done. So that I put it to you is technical speak to do exactly that.
Another point I would note there, and again, partly witness training, is Tim was very good in repeating. He put the point to me. If I didn't agree, he put his point, and he left that last message in the tribunal's mind, which is a technique you need to watch. Don't let the advocate do that. You need to say, no, as I've just explained to you, I can't comment either way. Yes. It's not for you to say whether evidence accepted. I simply can't confirm.
Yes.
And the judge will normally step in then. And I've even heard judges saying, look, why are you asking this witness? If they say they don't know, they don't know. So don't be afraid to challenge the advocate. You sometimes feel on the back foot.
Yes.
The evidence is yours. You keep control of it.
Yes, quite so. Because for those of you that have ever sort of delivered or been involved in any kind of presentation skills training, you remember that the last thing that somebody says in a presentation is something that sticks in the mind. And that's exactly that same principle being sort of played through here in this context. So the next thing we're going to have a look at is the challenge that she was the best person for the job. So the defense, you'll remember, is that she was selected because she was the best person for the job. So we're going to see that part of the evidence now being challenged in cross-examination. So we'll go to that bit next.
Okay. Well, talking about relationships, you talk about the communication problems that my client had. It's correct that you failed to address those alleged communication problems with her.
They had been raised by clients. She was new. I think she'd only been in the business for 2 months. I didn't really want to upset her at the early stages, and this was an opportunity both for the business and to resolve any potential conflicts that had arisen. And therefore, I was killing two birds with one stone. So that was one of the main drives, really. It was an opportunity for her and to resolve an issue which had arisen.
Okay, but you didn't raise the problems specifically with my client, did you?
I didn't. It was just one of those issues which had come up, and I wanted to give her the opportunity to prove herself rather than address an issue which had been raised.
Okay, and you say in paragraph 3 that one of the issue was that had been raised by one of the clients was the tone of her emails over the phone, and that she came across as abrupt and rude. How so?
Just very curt. In sales, it's all about developing relationships, and she seemed very blunt at times, very curt with people. And I'd found that myself as a manager on the odd occasion when we'd met, spoken. She could be like that on occasion. So, as I say, one of those things, and an opportunity arose which would help us resolve, the needs of the business and avoid that potential issue arising again.
In paragraph 4, you put those shortcomings down to what you describe as, quote, a cultural difference.
Yeah, it just seemed to be her way. She was very direct. She was very, at times, curt. That just seemed to be something that I've noticed. It can arise culturally. It's just a bit a general comment, but it was something that was coming to the fore, yes.
And in paragraph 9, you again make the same point, the communication style, and as I thought, it might be cultural.
Yeah, it might be. Not that it was. It just might be. I mean, people can be abrupt, irrespective of their nationality, etc. But she was English.
Well,
she just appeared to be abrupt with people at times. And I say sometimes, not all the time. So it could be any number of factors. But sometimes she was abrupt and painful.
There's no ambiguity in what you say, is there, in paragraph 4? I just put it down to being a cultural difference, is what you say in your statement, isn't it?
I do say that, but when I made the decision was to address the concern clients had raised, and that there was an opportunity. That wasn't.
It's not what I'm asking you, Mr. Fletcher. What do you mean by being a cultural difference?
Well, we all have our backgrounds and cultures, and sometimes your way of addressing people can be influenced by your upbringing. So possibly that's what I mean by that.
So the cultural difference, you're talking there about my client's Polish parentage, aren't you?
Potentially, yes.
Yeah.
But it's one of those things. I wasn't putting it down to that. I just had clients complaining, and it was a way of resolving it. It was a pure business decision. Nothing really. Nationality wasn't in my mind.
Well, let me take you to paragraph 9 of your statement. You go on and expressly say it seems a good fit for her to develop markets in Poland as that's her nationality. So clearly nationality was in your mind at the time that you made that decision, was it not?
Yeah, I made that statement, sometime after I'd made the decision. The real issue was I had a complaint from a client. We had a new opportunity in Poland. But on reflection, it does seem like a good fit, yes.
So I asked you at the beginning that your statement was true and accurate to the best of your knowledge and belief. Are you now saying that this statement's wrong?
Well, it is true. She's got Polish heritage. I've got Chinese friends, and they understand the culture and behaviours and good and saving face, for example. It's a natural fit. It's not. That's not the reason for the decision.
But the point is, Mr. Fletcher, you're criticising my client's communication skills or lack of them due to cultural differences, aren't you?
I'm not criticising her at all. My clients have raised issues with her communication style,
which you are attributing to, quote, cultural differences, aren't you?
It may have been that, but this was an opportunity to help her develop her career with ourselves.
Oof.
Interesting, the body language. Even though I'm role acting, you can see how uncomfortable I am, jigging around on the seat, and feeling in my face. The body language has completely changed. So again, important to watch as well as listen.
Absolutely right. Absolutely right. And of course, the judge will be taking all of that into account.
Absolutely.
When they're hearing that evidence. So talk to me through the process then, Stephen, in terms of decision being made, statement being written, statement now being cross-examined on. What's gone wrong here? What's
gone wrong is I don't think this witness has either read his statement since he just rattled it off, or he's not had it read independently. It's got to be your statement, it's got to be true, and it's got to be accurate. But you've got to think about what you say. So you can see even the slightest word here can be leapt upon by the lawyer, or even just a lay representative. And that has put me in this second section on the back foot. So I should have just stayed with my decision at the time was I had a complaint in from the client. Let them pull out the bit about the cultural background of the parents, etc. Don't try and explain things later. Just say, that was my reason, that was a clear decision. The more you expand, the more you'll get questioned. And that's a classic example in this cross-examination.
Lovely. Okay. Some comments on the chat coming through here. He should have tackled her communication skills at the time. Absolutely right. Absolutely right. If that had been addressed, would we even be here in the first place? Yes, and an interesting point. I'm afraid, Mr. Fletcher, your statement is being perceived to be more weak now. Now you're being cross-examined.
Good, very good. But this is a classic, isn't it? And I know you do a lot of training along this lines. Is that difficult conversations? Nobody wants to have that conversation. It is difficult, but there's a way of doing it. You can say, look, I've had a complaint in. We've got an opportunity, etc., etc. Document that, unless we'd have put this case in a completely different light.
And it could be that the two are entirely coincidental. It could be, but it certainly doesn't look that way with the benefit of this lens being put over it. And there lies the challenge, doesn't it, in that sense? Yeah, absolutely. And it could be, on the other hand, that the claimant has jumped on Mr. Fletcher's unconscious bias and scapegoated him. On the other hand, it could have been, absolutely. She could have been felt under pressure and thought, actually, I'm going to kind of extricate myself from the situation, and it's somebody else's fault, it's not mine. That could equally be the case too. I can see that, but the link between the incidents is becoming challenging here, isn't it, as this evidence is coming through?
You could have strengthened this position so much easier, and we're limited by time, but you could have been clear to say, look, here's the complaint, sat down, had a conversation with. The logical solution was to move it from that client and to move to, we had an opportunity, and then make no reference to the name, and then you could have, that point made earlier, whether she married with that, gained that name through marriage or through family, it's irrelevant, absolutely irrelevant. It was just a natural business decision, which was nothing to do with the ethnicity.
Yes.
This person's dug himself into a hole through a poor statement.
Yes, indeed. And so the last part of the cross-examination on the discrimination complaint is really to make this link. So we've heard in cross-examination that there was a suggestion that there isn't a link between her being her heritage and the selection. This last section of cross-examination is absolutely looking to try and establish that that's the case. So let's have a look at where Tim goes with this one in terms of cross-examination.
You obviously say again in paragraph 9 that that's her nationality. You accept that that's incorrect, and it's an incorrect assumption on your part, wasn't it?
It's probably not the right way to phrase it, yes. Yeah. But it's true. She has Polish heritage, yes.
Well, she doesn't, does she?
She's a Polish parent.
She's a British national with Polish parentage. Yes. You assumed Polish nationality because of a surname, didn't you?
No, I mean, obviously, I'm aware of her name, but the main thing was in the office. She often talks about her parents and their Polish upbringing, and when they came across. So I'm aware of it more from that than, I don't make a presumption from her name.
Isn't it fair to say that you made assumption about my client's nationality and suitability for that business development work in Poland?
I don't accept that. No.
Would you accept in hindsight that the client wasn't necessarily, as you say, the best suited for the Polish work if she was not Polish, doesn't speak fluent Polish, cannot read or write in Polish, and has or lacks less experience of business development in an untapped market than other people?
I can only tell you what I said before. She's experienced in sales. She's experienced in developing new sales. The requirement to read or speak or write in Polish was not a requirement for that role. The hotel industry is infamous for their ability to speak and converse in English, and that's all that was required.
You'd accept that placing her into that role without adjusting her targets represented a disadvantage to her?
But as I say, that's something that we had a conversation. She never raised the issue of targets, and that would have been reviewed as things progressed within the financial year. Those adjustments can be made. They weren't made. I will accept that they weren't made at the time of the conversation, but this was very early stages.
Okay, so that takes us to the final point then that they were looking to explore with Mr. Fletcher. Stephen, thoughts on where we've got to here in terms of how this evidence has come across?
I'd be interested to see what other people think on that, but my what I would observe is when a judge is listening to the evidence, they're also observing the behaviours. So I'd be interested in, when we pick that up later, I don't know whether, I think we're having another vote, but it'd be interesting to see who you preferred. Forget too much what they're saying. If it's one word against another, why you prefer one person over the other. I know my views on that, but I won't give that away just yet. But I think what this witness did do is he was quite clear and categoric as in what was required for the role. So you see the witness is warming up, but I think he's lost the edge. It's too late into the evidence. So yeah, I think try and repair a bad thing here, did so a bit better, but far too late in the evidence.
So we need to look at the final part of the evidence, which is in relation to the complaint of harassment. And remember what Mr. Fletcher said in his evidence is he can't recall making that statement. So of course, Tim's role as Agnes's advocate is to challenge that perspective and see if they can discharge the burden, which is to say it's more likely than not that it was said. So let's have a look at how this was handled, how this is handled.
You accept that if you mock someone about something, it might cause them upset or offence?
Well, you say mock. I don't accept that I've mocked anybody.
I'm not asking you that. I'm asking you if you did mock somebody about anything, would you accept that it could cause somebody upset?
I accept people can take offence at times, but certainly don't believe that I mock anybody.
Okay. There's something that I'm referring to, could be anything, couldn't it? It could be a hobby, it could be someone's background, it could be their appearance, it could be the way they're dressed.
It could be.
Yeah. And it could also be their nationality or a combination of things.
It could be, then yes, it could be a combination of things, yes.
And you'd accept, would you, that it's correct that if you upset or offence could be more acute if you were being mocked or teased in front of people that you hadn't met before?
It would change the circumstance, but that's not what this is we're talking about here. This was a team that which she was part of, and yes, we'd been in lockdown, but we'd all come together, and it was an opportunity for us all to meet. It wasn't a team she didn't know, it weren't people that she didn't know.
Well, let me take you to paragraph 11 of your statement, the second sentence. You say, I said it casually when we were all remarking on having either not met or seen each other in such a long time.
Exactly, such a long time. And COVID lasted quite a long time, didn't it? So we hadn't seen each other. But what you're assuming there is that I've said what she alleges, and I haven't.
Okay. So you do accept that in relation to the incident on the 29th of October, that you made comments about my client's dress or appearance?
I said something. I recall saying something about a suit, much as I would say to another friend of mine about his ties. It was just a nice comment about the tie. So
you made comments about the way my client was dressed.
I don't recall saying anything or connecting it in any way with regard to her nationality or anything you're trying to imply.
Okay. And in that sense, you say very importantly that you cannot recall referring to a nationality.
No,
it's possible that you could have done then, isn't it?
I wouldn't. These things happened some time ago. I don't recall saying anything like that along those. Normally, I would just say, "Well, that's a nice suit," or "That's a nice tie."
I accept that you're saying that you don't recall referring to a nationality, but it follows, does it not, that if you can't recall having done something, it's possible that something could have happened.
I don't accept that, no.
You don't accept that.
I don't accept that. You're making an assumption. You're implying either way. I'm just being honest with you to say, look, I can't recall every word I've said in a casual past, but I do recall commenting on a suit. I don't recall, as far as I can remember, relating that to a nationality. I'm not even sure how I would have related it to nationality, even if I had.
You have seen my client's statement in relation to the complaint that she makes. She's very clear in her recollection, isn't it, that you made reference to a quote Polish power outfit.
I don't recall saying that. No.
No, precisely. She's very clear. You don't recall, do you?
I recall making a comment about a suit. I can't recall precisely what was said, but I can't imagine I would have said anything or how I would have related that to a nationality.
Thank you. No further questions.
Thank you.
Okay, so let's explore what's gone on here, because of course what Tim can't say to you as Mr. Fletcher, can he, Stephen, is you're lying.
No, there's a degree of formality and respect, but I think the last comment in the chat has said that surely manager here, if it's his character, would strongly refute it rather than not recall it. And this is extreme. This is the most important lesson from this section: is you've got to be categorically clear, because it creates room for doubt. And as Tim said there, if you can't remember, then you can't then deny it. So you need to be clear. You either remember it or you don't.
Yeah. And what Tim is offering the judge here is, well, which is the better quality evidence? Agnes has been very clear, he said, but you just simply can't recall. Make the choice. And of course, this can be equally relevant when you're conducting internal investigations, can't it, Stephen? If you have witnesses in investigations that say, I can't remember, look at what else they can remember around it and question how plausible it is that suddenly they can remember exactly what they had for breakfast, what they wore on that morning, but then in that row that they had in that meeting, that was the first meeting of the morning, they can't remember what they said. Just doesn't seem to ring true, does it?
Absolutely not. And I think some of you again on the chat said, what is a Polish power suit? If this had been a grievance and I was investigating that's the point I would have made to the claimant as well. Don't be afraid just because they're offended by it. Actually, you can dig on that and say, well, what does that mean? I've not heard that phrase before. So you can create doubt either way. So be very, very clear what you hear, what you see, and if you didn't, explain why. And that's what I think this witness does poorly, is that he denies things but then doesn't explain the reason as to to the thinking or the reasons behind his denial.
Yeah.
So yeah, don't be pushed and pulled by the advocate. I think it's a lesson here, and be very, very clear.
Lovely. So aside from any re-examination, which would be to address any points of lack of clarity or questions from the judge, this would be the end of the evidence that was available for the judge to make their decision. So what we're going to do now is take we'll call it a mini break, if that's all right. So we'll take it until 4 o'clock, and then immediately after the break I'll run another quick poll, because that will help us sort of decide where this decision is going to go, and we'll have a look at closing submissions, and then the last section of the day is that you will hear the judgment from the case based on the guidance that you give us on the closing submissions. So stay in the call as before. Let's get into the right sort of experience and practice, as Stephen said last time. Stay in the call, just pop yourselves on mute, and obviously keep cameras off, and we'll do the same, and we'll see you on the hour, and we'll run another poll, see where we're at. Welcome back, everyone. So home stretch. Let's see what our thoughts are having heard from all of the evidence. So I'm just going to reshare my screen and flash up the QR code again in case you need it to go back onto the Mentimeter. If you're already there, feel free to start voting on that first question. So the third time of asking, will the claimant win her direct discrimination claim? And I'll go to that in just a moment. Give you a chance to re-click on if you need to. So it's settling there, 57 in favour of yes, I think, Stephen, don't you?
Yeah, I'd be interested the reasons why, actually, when we did the submissions point.
Absolutely right. So let's go 17 in favour of no. I don't think it's going to change on the basis of any other submissions here. Let's go on to the next one then. The third vote then of the harassment. Will Agnes win her claim of harassment? Much more balanced compared to previously. Shall we settle it there? That normally triggers a flurry. Okay, I think we're settled there at yes 26 and no 44. So we've got a consistency in terms of the harassment complaint throughout. No's each vote. And we've got a change, yes, no, and then yes on the harassment complaint. Well, that really helps the judge. Thank you very much for that. What we want to have a look at is the submissions, therefore. Stop sharing there for a moment. So, Stephen, talk us through closing submissions, and then we'll have a look at doing some, shall we?
Yeah, the starting point is Darren, our chairman. He always upsets me by saying that, I can't remember what the percentage is, but the chances of changing the judge's view are very, very slim, is the polite version. But in reality, this is your opportunity to put the strengths of your case for the respondent and for the claimant in turn to the judge. So what you're trying to make is your best points, and if you can, to address any negative points that have been made. And that's probably the more important. It's to challenge and to give your evidence on your weaknesses, because that is the bit where you're going to tip the balance, if you're going to tip the balance at all. There's no formality to it. The judges sometimes ask questions, just the points they want to clarify. The last one I was at, he didn't want to hear any repetition of the evidence. He just wanted brief submissions on the law. So yeah, what we need to do now is together try and come up with the key points that you wish to make in favour of each party.
So we've helped out here a little bit, and we've got 3 submissions on behalf of the claimant first. So we'll go back to Mentimeter. We've given you 3 options in no particular order. What we'd like is your view as to which is the strongest on behalf of the claimant. So we'll do that first, and then we'll hear any other observations on the chat in a moment. So let's do the claimant's closing submissions first. So I'll just reshare my screen. Same Mentimeter for those of you who are still in it. If you just, you'll see it'll have flicked on to the next question. For those of you who need it, I will just show you voting instructions again. I think this is the closest I've ever seen the first and second one, don't you?
Yeah, I've not seen them jump around quite as much, no.
Wonderful. So Stephen, talk us through the significance of the difference between the first and the second one, seeing as these are our most popular. Neither are incorrect. None of these are incorrect, are they, in terms of the points being made? Yeah,
I think this reflects the swing that we saw in the Mentimeter poll. I think it's more a case that the respondent here hasn't been clear enough in the evidence. And point 1 and 2, whilst they are distinct, actually, they both reflect the failing in the evidence of the respondent's witness and the lack of documentary evidence. So I noticed on the chat, lots of people were saying should have had the conversation. Not only should they have the conversation, it should have been documented. There was no evidence of the complaint in the bundle to even back that up. Now, Tim didn't go into that at all. But if that was the reason, where's the evidence of that complaint?
Yes, quite.
So, you know, you've really got to start from the beginning and documentary evidence. And without that, then it may have been assumptions on the part of the claimant, but sympathy often lies with the claimant in these cases. If there's a benefit of doubt, then they'll probably go with the claimant. Particularly in relation to the Polish power suit comment, it was so unusual that it's not one that somebody would make up. So no. Sometimes I've seen, and I've actually run cases on that basis, is that it's, you know, you might have denied it, but actually it's so detailed or it's so precise in what's been said that actually it gives it an element of strength
yes.
when you put it forward. So
that sort of thing is not easy to make up. Is the
no, absolutely.
No, exactly.
It's odd, and because of its oddness, it's something you wouldn't normally make up. I think yes. Luke, the delegate, I think his name was Luke, actually said the advocate should have leapt on this change in language that she used on the stand. That would have undermined it.
Yeah.
So yeah, I think points 1 and 2 are very close, but I think that's due to failing the respondent's evidence.
Absolutely right. Yeah. So and the second point specifically here is that the respondent has not satisfied that reversed burden. Is a key point here, isn't it? And this is then showing that the assumption ran all the way through it. So it not only satisfied the claimant's initial burden, but also it did not allow the respondent to satisfy their burden, that it had nothing to do with it.
Yeah, I wouldn't say it's common, but you do find it in a lot of cases where individuals raise not just one element of protected characteristic, they'll raise 2, sometimes 3. Rare that they go beyond that, but actually what they're doing is they're throwing so many things to stick, and in this case some of it stuck.
Yes. Yeah, quite so. So let's look at these submissions for the claimant in relation to the harassment complaint. Let's have a look at that one next. Interesting. So a clear front runner here is the can't recall point, the point we were discussing previously, wasn't it, in terms of the balance of probabilities and the relative qualities of the evidence.
I think we emphasise that in terms of discussion, that's one point I would say here is that irrespective, the lack of recollection, and I also think the body language, a lack of confidence, whereas the individual claimant got quite emotional. You could hear the voice got quite emotional at one point, but she was very categorical on what was said. She was certain the statement was said, even if it was an odd statement. That's what I heard. And that tips the balance. I always refer to this on my training courses, so apologies to those that may have attended before, but I remember a particular hearing. I just joined a company as an in-house lawyer, and my witness made what I thought was a negative point, one of those you just want to bang your head on the desk. but the judge, I remember saying, said, look, they struggled to come to a decision, but they preferred the evidence of, and they preferred the evidence of my witness because she'd been quite detrimental in her evidence to herself, but she was honest. Yes. It was that degree of honesty that swung them, and they just said, you know, we accept that she may be a firm manager, but she's not a bully.
Yes.
So they really go on who they like and what they don't like if the evidence is unclear. And the clearer you are, and the more categorical you are and reasonable you are, the better.
Indeed. Okay, let's have a look at the respondent submissions then, and then we'll get to the judgment. So what are the strongest points for the respondent's submission about the discrimination complaint? Have a look at these for me and tell us what you think is the strongest point. This is very interesting. So let's have a look at this one. She did not suffer detriment. We could have adjusted her target. So the point here is she jumped too soon. She didn't suffer a detriment as a result of this, which is a very interesting observation.
Strange enough, I would have put that last.
Yeah, it's interesting. Yeah.
And now that's the difference between common sense and legal argument. So what I would have run is, look, this wasn't anything to do with ethnicity or heritage. But in any event, if you're not agreed with me that there was a good reason, there was a complaint, she was suitably qualified. In any event, she did not suffer a detriment because would be my final argument. But
yes,
I go
so
with
you
the
would
majority.
Have swapped two and one in that respect, second and first. Yeah. And interestingly, the fourth one, which is the least popular, but it is often the one that you hear said anecdotally about these sorts of cases. Oh, well, that was the true reason, but it obviously rightly did not feature in this case. But you can see often that does play through in particularly in managers' minds when this sort of happens. Let's have a look at the harassment complaint then, and then let's make some decisions. So what's the strongest point of the respondent's submissions in terms of this harassment complaint? This is a difficult one, I think, don't you, in terms of submissions?
I do, because it's so subjective. So if we think about the definition of harassment, it's something that has caused or is likely to cause offence in plain English, or affect somebody's dignity. And if it was, that would be bullying, and it becomes harassment if she can link it to her nationality in this case. It's very difficult to go around, and that's that last point there. No reasonable person would have been offended. That's a very, very thin argument to run in reality, because it's looked at through the eyes of the individual. It would have to be an extremely strained grievance, or a totally unreasonable grievance for it not to tick that box of amounting to affecting someone's dignity and harassment.
And related to a protected characteristic, by dint of the reference to a Polish power suit, assuming the evidence goes in favour that it was said, it's very difficult to say that it's not related to it.
Yes.
I do remember somebody saying to me, which I thought was a very valiant argument, it could have been a polished power suit, which I thought was super. I so wish I thought of that when we were writing this case.
That sounds like a barrister's argument. I like that.
Doesn't it just?
Yeah, it might be wrong, but here it is. Yeah.
Indeed.
Yeah, I think this point of relying on there's no evidence, that's a difficult one, because that allows the judge and the tribunal to go either way. There's no evidence to say it did or it didn't. So I actually think point 2 for me, she didn't speak up at the time. If she was that offended, why wasn't it raised at the time? Why didn't you mention it to anybody, and why has nobody supported that evidence? This is simply a fabrication, might be my stronger argument, but it's choices, and this is the strategy you need to work out when you're working with your lawyers on these sort of cases. Work out what your strategy is, where's your weakness, and how are we going to address that? And you need to have that conversation before you start thinking about your statements, really.
Yes, indeed. Okay, so let's see what the outturn of this case is then. So normally,
sorry to interrupt, Vicky. Can I just?
Fire away.
There was one point I keep meaning to address it. Now, there was somebody put in the chat about surely the lawyer should have a dummy run. I would always have a pre-hearing meeting with my witnesses, and I'm sure you did as well, Vicky. The difficulty you've got is we can't encourage you to tell an untruth. Secondly, it depends on the witnesses. Some witnesses will not be coached. They will not. I had a very senior person, MD, that refused to go through the statement. We had to put his arm up his back. Turned out to be the worst witness I ever had. He read it like a 3-year-old. So some people will not be coached. Some people will be coached, and then they become too fixed and unrealistic, and therefore don't come across as an authentic and honest witness. So it really depends on your witnesses. It really depends. I think the key thing is not to coach or to do dummy runs, but just to say, look, you're going to be pushed on this area. Think about your answer. You can help them and help them think about how they're going to answer it. But there's a fine line between changing the evidence and actually unnerving the witness by forcing them. But definitely have a pre-hearing meeting. Don't just walk up to a tribunal and meet your advocate in the tribunal room.
And certainly what we can do is provide training for witnesses, give them the experience, explore the techniques, think about how they would deal with a situation, which is not about coaching them how to answer it, but also, but it is about giving them a sense of understanding the process that they are going through. In that sense, you can certainly do that. Yeah,
that's on the chat as people. I think there's two.
Yeah.
Yes, witness. The answer is yes. We can give training on witnesses, particularly if you go to a hearing. It's worth having that training.
Yeah, absolutely. Okay, so what would normally happen would be there'd be a short adjournment while the judge reflected and made their decision. Normally they will write their decision out. So I'm going to give you as close to a realistic as I can in that sense, to give you a sense of it being read out. Often what happens in that judgment is you don't get the actual decision until the end of having sort of run through the evidence. I'm not going to do that today because I do think it is useful to hear the decision and then hear how the evidence is being explained in the context of the decision. So I'm going to slightly adjust what some judges do, not all of them by any means. Obviously, it's a personal thing, but let me give you pretty close to the reality, taking into account the points that you've just given us in these closing submissions. This is the judgment of this mock tribunal in the case of Agnieszka Trosowska and Randolph and Tanner Interiors and James Fletcher. The tribunal has heard evidence under oath from the following witnesses: Agnieszka Trzaskowska, the claimant, and James Fletcher, the second respondent, and a manager at the first respondent. From the evidence heard, this tribunal determines as follows: direct race discrimination. The claimant was subjected to race discrimination. This claim is well-founded and succeeds. Harassment. The claimant was subjected to harassment on grounds of race. This claim is also well-founded and succeeds. And here are the reasons for the decision. The claimant claims that the reason for her treatment is her race. Section 9 of the Equality Act has a non-exhaustive definition. It says that it includes colour, nationality, and ethnic and national origins. The claimant identifies as being of Polish ethnic origin for the purposes of this claim, albeit she has made clear to us in evidence that she was not a Polish national. The House of Lords, now the Supreme Court, has given us guidance in Mandler and Dowell-Lee that the question of ethnic origin is to be interpreted widely. I am satisfied that the claimant's heritage, Polish, amounted to an ethnic origin. Direct discrimination, the relevant law, is in section 13 of the Equality Act, and it is that a person discriminates against another if, because of a protected characteristic, A treats B less favourably than A treats or would treat others. In terms of the burden of proof, section 136 of that same act says that I have to ask myself two questions. One, are there facts from which this court could decide, in the absence of any other explanation, that discrimination has occurred? And if so, two, did the respondents not discriminate? There is guidance from the Court of Appeal in Mandrassi and Nomura International PLC that the burden of proof does not shift simply because the claimant has demonstrated a difference in national origin and a difference in treatment. Those bare facts only indicate a possibility of discrimination, and that there is, and not without more, if there's sufficient material from which this tribunal could conclude that on the balance of probabilities, the respondent committed the unlawful act of discrimination. The claimant must show a difference in national origin and a difference in treatment and a causal connection between those two. Then, if the burden does shift, the Court of Appeal tells us in Aigen and Wong that it is for the respondent to prove to this tribunal that the reasons for the treatment were in no sense whatsoever because of the claimant's national origin. So, why was the claimant selected to manage the emerging market in Poland? The claimant has relied on the fact that she was of Polish heritage, and it is the respondent's submission that it was an assumption on her part that the reason for her selection was her experience from her previous role. I'm required to consider what the evidence indicates on the balance of probabilities was the conscious or subconscious mental processes of the respondent in selecting the claimant to manage that emerging market. This tribunal has heard argument from the respondent that by selecting the claimant, they were selecting their best player. Yet the respondent has advanced no evidence to demonstrate any objective assessment of the claimant's abilities in selecting her for this task. Furthermore, Mr. Fletcher admitted in evidence that other members of the team had more experience of developing new markets. I therefore draw the inference that the claimant's Polish ethnic heritage was relevant to Mr. Fletcher's having chosen the claimant. Furthermore, we've heard from Mr. Fletcher, the claimant's manager, that there had been concerns about her communication style that he thought might be cultural and that she might prefer working on this task. In his evidence to this tribunal, Mr. Fletcher sought to distance himself from that previous conclusion that the communication issues were cultural, but I am not satisfied that the respondent has established that the claimant's selection was in no sense whatsoever because of her national origin. In doing so, I recognise that discrimination need not be ill-intentioned and can be based on an assumption, for an example, that someone would be a good or a better fit, or that behaviour is due to culture. Was that selection adverse or detrimental? It's the respondent's case that the selection of the claimant was not adverse or detrimental to her, but the House of Lords has given us evidence, or given us guidance on the meaning of detrimental treatment in Shamoon and the Chief Constable of Royal Ulster Constabulary, where it was held that a worker suffers a detriment if a reasonable worker would or might take that view. And the claimant in her evidence referred to a lack of support to develop a new market and the fact that the claimant's target was not adjusted to reflect that Poland was a new market. Whilst the respondent's case was that the selection was in fact more favourable to her in that it was making positive use of her experience, Mr. Fletcher admitted in evidence that other members of the team had prior experience of establishing new markets, whereas the claimant did not. I'm therefore satisfied that on the balance of probabilities, choosing the claimant without giving her support, whether in the form of reducing her a target or in other ways, was detrimental and amounted to less favourable treatment. Turning to the harassment complaint, we have heard from the claimant that Mr. Fletcher used the phrase Polish power suit in the team meeting, which she described as making her feel embarrassed and angry. Mr. Fletcher's evidence, he says that he does not recall using the word Polish, although he does remember making some reference to the claimant's clothing. Neither party has called evidence to assist the tribunal in respect of this allegation. We have found the claimant to be more specific, consistent, and detailed in her evidence compared to Mr. Fletcher, and as such, we prefer the evidence of the claimant. We therefore conclude on the balance of probabilities that the phrase Polish power suit or Polish power outfit was said by Mr. Fletcher. We also accept that the comment creating an adverse environment for the claimant and accept her evidence that she felt it created a hostile environment for her. We are mindful that this is a one-off incident and yet find that it is reasonable to regard that the conduct as having that effect on her, particularly taking into account the surrounding circumstances. This concludes my judgment. A further hearing will be arranged at a later date on the question of remedies, including to consider the issue of a lack of compliance by the claimant with the ACAS code of practice as far as raising her complaint internally and any potential reduction in compensation. So it's a win for the claimant on this particular case. Now, ordinarily, what would happen would be people would just disappear at this point. There would be no further discussion. We've obviously got the benefit of talking about it, but immediate thoughts on the chat would be so valuable to hear in terms of thoughts on that decision. I'm conscious that this tribunal is at risk of outstaying its welcome, Joe. So I'm going to bring it to a conclusion there with thanks for all the comments and observations on the chat. It makes such a difference. We are going to send you some resources, some are around on performance management. How do you manage these sorts of conversations? And Stephen, I know that for those of you that are employers in the room, because as a business, we act for some of the UK's largest employers. If you have questions on tribunal, cases that you've got upcoming, and happy to sort of spend some time with you, just drop us a note and we'll happily link in with us and we'll happily arrange that for you. But I don't want to take all the time. So Joe, I'm going to hand over to you to close up for today.
Brilliant. Thanks very much. Wow, what a good couple of hours that was. How interesting and exciting. So I'd just like to say a massive thanks to Vicky and Stephen for all the effort that you've put in. Yeah, really interesting. And I'm glad that, I'm sure that everybody else has thought the same. So I'm going to send out an email to everybody that's registered following the event. This will include links to the Vista's resources that Vicky's just referred to, and this will be useful for you following today's session. I'm also going to put a post on LinkedIn for you to add a comment about the session, and also if you would like a copy of the recording, then add your comment to that LinkedIn post. In terms of HR Recruit, we also run a guild networking group for HR professionals. It's a bit similar to WhatsApp, where members can ask questions, network and share ideas. I think we've got about 700 people registered in there. So the link to sign up for that will be on the email. And finally, if anyone is actually recruiting, then within the group, we've also got accountants to recruit and finance director recruit within the group. But finally, I'd just like to say a massive thanks to Vicky and Stephen for the time, and also to everybody for tuning in. Thanks very much, and I hope you've enjoyed it.